Yes, it does say that I am alive, and that's a good thing. Oh, it says live for 31 seconds. Okay. Oh, I get it now. I got it. Oh my goodness gracious, Nat. Don't cover your eyes, Nat. Do not cover your eyes because oh, no sound. I said, Nat, you and you alone get to see this horrifically horrible head first. Nobody else is looking at it. And you got to look at it while I lip everything for a long time. This is the A, B, C, D, E. I know sign language. Yes, and I'm glad you noticed. I said, look, I'm going to be able to grow some cornrows pretty soon, grow some pigtails, maybe out the side, right? Sewer Dog, the Patriot, good to see you. The Benghazi Rabbit, good to see you, Benghazi Rabbit. And guess what I get to do? Guess what I get to do with you folks? Is it? Yes, it is 4:20 somewhere. And look at me go. Look at me go. Congratulations. I got my I got my medical marijuana card. Puff Dog, we are legit. We are legit, Puff. My horticulturalist. Me and Puff. I mean, I don't have to hide anymore. And that right there is a nice what's that one right there? That one is a Pup Dog Special. This is Cactus OG from out there in Arizona way. Yes, 4:20 somewhere. I need my medicine just to keep up with these fuckers I'm dealing with, if you know what I mean. And they're like, now they're like, wait a second. How is this pothead whooping us? How these prosecutors are not now like, that's why he whooped us. All these prosecutors that I've put to shame, two to be specific, and more other attorneys per se, not specifically prosecutors, but other attorneys too. Yeah, I bet you do, Sword Dog. All right. So maybe that could be the reason why I forgot to turn my microphone on, right? Maybe. We'll never know. But Nat got to see my head first. Well, let me tell you, I have a hearing coming up. It doesn't matter, brother. I smoke anyway. Yes, Sir Dog the Patriot. I do not disagree. I mean, your name gives it away, though. Your name gives it away. Not the Sword Dog or the Patriot, but that 420 leads me to believe something. I forget. See, what did we do? You'll be dead before they ever legalize it in North Carolina? I know. It's terrible. Such a progressive state, too. All right. So, I got a new court date. Ding, 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 ding. May 5th, 2024. And how long has it been? Can anybody tell me how long I've been at trial down here in McDowell County, West Virginia? I'll give you a cookie if you could give me a proximity. 1 month? 2 months? How long has it been? I mean, it has been quite a bit of time. 18 months. You'd think it's been 18 months. Nah. Sewer Dog the Patriot. 2 fucking years. Holy shit. Could it be that bad? On that, you're short. And Sewer Dog the Patriot's been paying the fuck attention. What's the matter with you, Nat? So what I'm about to show you, 47 years, 2 months, 3 days, and 21 hours. Oh, that is really specific, Anon Mouse. Maybe in mice years, right? Maybe in mice years. Or mouse ears. Mice? Maces? That's funny. Okay. So, Sewer Dog. Ding, 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 ding. You got it right. So, okay. This all started not way back in August of 2022. No, August 6th. No, it didn't start back then. It started all after my trial. The one that didn't finish, the one I objected to. Your Honor, I didn't get that evidence. It all started there. Because really, before that, I really didn't get involved except for one motion to continue. Up to that motion to continue, it was, I'll get to it, because I have a presentation for the judge, the new magistrate, because Magistrate Mitchell is out. Magistrate Mitchell is out. Now, did I disqualify him? No, I didn't disqualify him. He had a heart attack. And he was riding his scooter and a rock hit him in the eyeball. So he needs eye surgery. Very convenient to have a heart attack at that point. I'm sorry, Your Honor. I didn't mean it that way. Very convenient to have a rock come up and kick you in the eye. I mean, it's never convenient when a motorcyclist, gets a rock in the eye. But, karma? Nah, that ain't nice. What's the matter with you? But the magistrate that sat in on my trial and heard my objection, Lion One, good to see you. Welcome. Okay. Did I bring my Copenhagen down here, dadgummit? Gummit, my Copenhagen. Hey, Betty Joe, can you roll me down a can of Copenhagen, please? Oh, there's somebody moving up there. She's going to roll me down. This is how I work, right? Yep. Go ahead, roll it down. Oh, it got stuck on the chute and the ladder. Because that's what I have coming down into the bunk hole, a chute and a ladder. Good throw. Did you see that throw? All right. I digress. So, my continuance. But here's what I'll do. I'm going to show you this document first. And this is the West Virginia courts, westvirginia.gov. It's my record. Let's see what they have to say. Okay. Oops. There we go. Now, I know it's very, 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 very small for you. Okay. But anyhow, I got two things on my record here in West Virginia. This right here from here down is 23 different daggum thingamajiggers. Misdemeanor complaint, warrant issued, initial appearance, bond and bail posted, service successful, notice of hearing, hearing event closed. Because he sent my daggum notice to hearing to the wrong address in North Carolina. So I was derelict and I didn't show up. And he issued a warrant for my arrest. So he issued a warrant for my arrest. Oh, no. So he ordered another notice of hearing. And I showed up. The next motion was another, not motion, but notice of hearing. There was a motion to continue. I wonder who gave that motion to continue. Could it be Miss Puckett? Puckett? I think that was Miss Puckett's motion to continue. I filed for a motion of dismissal and another motion. I wonder what that motion is. Note the dates, 2/21/2023. See, over here. But we'll get to that in a second. All right. Now we can blow this up. Sorry about that. Is that better? No, I am not in Philippi, Janice Cole. Okay. So here's the date over here. I was arrested on August 6th of 2022. Here we are on 2/17. 6 months later, a motion to continue. All right, this is what they have on theirs. See? Now, that's just an example. Now, let's go to mine, shall we? Same document, but just a little bit different. Let's start off by saying this. Here it is right here. See this? 8/12. This is what I've included. And I'll explain this here in a second. This is real easy to explain. Let me just get this on here. All the way on. Get me off here. All right. From 8/6 or 7, 2022 till 5/2/2024. See this? It's been 635 calendar days. See, right here? 203 skipped days. The skipped days are 90 Saturdays, 91 Sundays, and 22 fucking holidays. Oh, the horror. Let's look at some of them holidays I've missed with my family. I couldn't go anywhere, and I was always worrying. Oh, we have Labor Day. I cannot miss Labor Day. Columbus Day? Fuck that, Columbus. Fucking indigenous killing machine is what he was. Indigenous people killing machine. Columbus Day. I didn't need Columbus Day anyhow. Election Day. I have got to go elect my magistrate judge. And I've got to go elect you, Miss Puckett. Puckett. Thank you for letting me have that day off, Miss Puckett, to vote for you, right? The tribe, good to see you. And Janice Cole, good to see you for the first time, too. I don't think I've ever seen you here before. But election day, vote Democrat. That's what they are down there in McDowell County. I know Brittany is. But that doesn't matter. They're all fucking corrupt. They're all from the same motherfucking tribe. The tribe. Okay. Let's see what other holidays I've missed. Let's get a little bit bigger. I have missed Veterans Day with my brothers and sisters in arms. Friday, November 11th, 2022. And Thanksgiving Day. I couldn't even eat turkey. Mashed potatoes. And I feel stuffed like a chicken. That's what or a turkey. Sorry. I'm so confused. I called a turkey a chicken on Thanksgiving Day. But I do feel like a chicken stuffed too. A chicken stuffed inside of a turkey. That's what I feel like. Let's put it that way. Cover my ass. Or, in a way. The day after Thanksgiving, I got to lay around and watch football. And then we got Christmas Day I've missed. The birth of Christ. How can you deny me that? Judge, Magistrate Mitchell. I'm not going to mention the new magistrate because he has nothing to do with it yet. I've never met the man. Well, I have met him, but he's done nothing to me. To warrant my wrath. So I'll keep this magistrate's name out of it for right now. But anyhow, New Year's Day. Not a good New Year for me. I'm still at trial. Look, 131 work days. 131 work days in, and I'm missing all these holidays. And look over here. Notice of hearing. Miss Puckett, 217. Motion to continue for the drone footage. That wasn't drone footage. We know the drone footage, don't we, Nat? The drone footage is there. All at the same time, I'm missing Martin Luther King Day, one of my heroes. I'm missing out on Martin Luther King Day about 131 days in. Now, we have to look up here, though. Okay, I didn't put it in there, but Martin Luther King Day. I asked for a speedy trial. Right here. 132 days in, I had the motion for a speedy trial and to quash the prosecutor's continuance for no drone footage. I filed that motion 2 days after she dropped that on me. And that was Puckett's motion for drone happened on the 17th. The hearing was scheduled, or the trial was scheduled on 2/22. How convenient. 17, 18, 19, 20, 21, 22. She asked for that continuance 5 days. Well, 3 work days, 5 total days. It was a weekend in there, right? So 3 takes it up to 330, 133, right? Of course, my speedy trial has been denied, I think. And you ask, well, why do work days matter? Why do work days matter? Well, work days is the way they calculate 120 days, which is one term. Why am I stuck on the speedy trial and the quashing of the prosecutor's continuance? Because first off, there is no drone footage, and I knew it after 7 months. Okay. And they didn't mention any drone footage in the discovery up to this point. So I filed a motion for a speedy trial to push them along. Like, hey, it's already been 7 fucking months, close to it. Let's move this along. And the judge says to me, Magistrate Mitchell, why, Mr. Ballin, why would you want this trial to be tried? I said, I'm ready right now, Your Honor. Let's do this. And of course, he turned down my quashing of the prosecutor's continuance for no drone footage. Now, this right here ended up being no drone footage. That's why it's named no drone footage. And that's all before President's Day in that particular year at 132 work days. So from the time of her motion to the time Mom in Yellow, there was a notice of a hearing right here. And that trial was coming up on 3/24. Well, the only problem with that is she dropped me my discovery with no drone footage on it 7 days before trial on the 15th. Over here's the 3/17, 150 days from her continuance to my continuance, because she dropped the evidence on me 7 days before trial. Now, my motions tell the story of 7 days before trial is not enough time by requirement of rule to drop on a defendant, especially 14,000 files, and a West Virginia State Police analysis of my phone and my GoPro. 7 days is not enough. So I had to file the motion to continue, and at the same time, I filed for a motion to return to my property, both my GoPro and my iPhone. That's why I have it named Miss Puckett Drops Discovery. 150 days in. This is the second discovery that she's dropped on me. I think maybe, yes. Second discovery out of 3. Third discovery happened at trial when they handed me another hard drive of their evidence. Okay, moving in to the next year. Look. So I filed my motion to continue. Oh, sorry, down here, for return of property on 3/17. It's 19 days between her motion to continue to my motion to continue. That's work days. 133 to 150. Now, on 3/24, that hearing was closed because I asked for a continuance for return of property and motion to continue. And because DA Puckett had given me it, and I explained it to it in this motion to continue why. And then I need to look at my own property because they aren't giving me everything I'm telling the judge in my motions. These motions, speedy trial, quash prosecutor's Jones, footage or continuance. Okay. So the hearing event was closed because of my continuance. Between the event being closed is 155 days to the next trial at 264 days. Why are work days important? Let me get off camera here. 239 work days from Ms. Puckett's motion to have a hearing. Notice Ms. Puckett filed a motion. My continuance is here. From here to her motion here is 84 days. What is the delay in the continuance and return of property of 84 days? And then you have a notice of hearing here on 7/27. That's 25 more days. Look, I'm in Labor Day, Veterans Day, Thanksgiving Day. Oh, another Thanksgiving Day I'm into. No more turkey again this year. And I missed Independence Day. Oh, that I have to delete that. Okay, only one Independence Day, but I did correct it in mine. I mean, I'm into Labor Day. I mean, what happens if my wife is pregnant? I think that's a very important month for women. That's when they get pregnant or start to deliver. Sorry. They'd get pregnant months earlier, 9 to be precise, or roundabout. So that day specifically is for women to have children. I always thought that government weed will set us free. Okay. Here I go. Missing another Veterans Day. Notice of hearing on the 27th. Ms. Puckett filed her motion for a hearing on the 27th. Isn't it funny how quickly they work? From that notice to hearing to my actual trial was 25 more days. Now we are sitting in a combined 264 work days. That'll hit the second 4th of July the same day. Right. Thin Blue Line Slayer. Creole, Brent, good to see you. Now we're at 264 work days. Why is that important? Can anybody tell me why 264 work days is important, or work days are important at all? Look, we're sitting November up here in between 8 and 4. I couldn't fit them all in down there. So I just, I went ahead and just added it up top a little bit more. They get it. You get it. The gist. Okay. So from the trial, the one that was testified to, the one the one that was attested to, and Magistrate Mitchell sat in on, and Brittany Puckett asked questions of witnesses, introduced evidence, presents evidence that I all along say I've never gotten in every one of my motions. The judge continues, said, get him the fucking, there's 3 continuances, he said. Get him another copy of all the videos, all the evidence. So he gave me his thumb drive. This specific thumb drive. Thank you, Trooper Jones. Thank you, Trooper Ricky Bobby Sue Jones, for this thumb drive, because now I have something to compare. So in between my trial, the trial was continued because I had to have time. I mean, don't I need to have time? Well, let's see how much time they gave me. Shall we see how much time between the trial that was continued, hearing event closed, 8:31 to the next hearing at 5/2/24, right? This right here is just a notice of a hearing, but the actual hearing is 5/2/24. That's 166 days, beans, and roots. In between my trial and my next motions hearing, it isn't even a next trial. All at the same time, I'm missing out on all these holidays, just waiting, sitting around, not bothering anybody. 166 days, work days, a total of 430 work days I've been on trial. Do you see how the chart flows? Now, let me show you the green. Okay, I was arrested on 8/6. Everything in green is Miss Puckett and the court. Even before I do anything, I ask for a jury trial. That's all I've done. Even before I do a fucking thing. It's at 131 work days with all of these holidays in between. I get it. 100. So, what do I do on day 132? I file a motion to dismiss. Why do I file this motion to dismiss? Anybody remember? Based upon the principles of a speedy fucking trial. I jumped right on them. Way too long, Your Honor. I haven't even filed. They filed a continuance. Which they're allowed to do. But I called them out. I filed a motion to dismiss a speedy trial. There it is. The same fucking day. But they don't tell you what motions I filed. I put them in there and quashed the prosecutor's continuance. Why did I do that? Because this is a bullshit fucking continuance. 7 months, 132 work days, and you didn't know that you had your own drone footage? You couldn't get your own drone footage in 7 months? Thin Blue Landslayer and I said, Thin Blue Landslayer, as soon as I told him about this motion to this drone footage that they continued for, he laughed. He said, there ain't no fucking drone footage right away. He laughed. And I laughed too. I was talking to my brother on the phone, you know. But anyhow, I don't feel like it's been speedy, Thin Blue Line Slayer. It has not been a speedy trial up to this point. So let me break down the numbers further. Okay. Up to this point, I have not been involved 131 days. That's the green. Okay. Now, I mean, this is only a few days later. Of course, I'm going to jump right on them. My motions, I jumped right on it. That's what you do. It's you attack these motherfuckers. Counterpunch. This is the first interference that I've had on President's Day. The President's Day. So, countered them within 3 days. Boom. Dismissal. Speedy trial. Prosecutors quash. Prosecutors. Now, in the next 19 days, we have a trial that's closed because of my continuance. We have a new notice of hearing. 137. I'm sorry. This trial right here was because of her continuance. Right here. This trial was because of my continuance. Event closed. Now, that's where I first come into it right here at 317. That's 150 days in before I really interfere, delay the court. They call it delaying the court. Now, what the word delay mean to court? What does delay mean in the court? Delay when it comes to the timing of a speedy trial. Do you see where I'm going? What defines a speedy trial? Exactly what is a speedy trial, and tell me how you know whether it's been violated or not. Can anybody tell me that? What defines a speedy trial? Is it 150 days? Work days. We got into the summer months where there isn't any holidays whatsoever, or spring months. Well, there are Valentine's Day and all that, but they don't do Valentine's Day. Yeah, pretty much all spring and summer. At this point, 150 days, it's been all her continuance or the court's delay and holidays. I mean, I definitely did not miss West Virginia Day. West Virginia Day is one of the most important days to me. Tuesday, June 20th, I made that one, 2023. Yeah, that was a humdinger. Okay. Event closed right here. That's because of my continuance and return of property. That was at 155 days. So 155 days in, continuance. That seems to be a standard. When you file a motion to continue, same thing with Miss Puckett's. 5-day delay between the trial cancel. I'm sorry, 2-day delay. No, 5-day delay between motion to continue and the trial being shut down. But I mean, it just so happens that it all happened 5 days apart. That's kind of odd too. I didn't think about that. But why are both of them at 5 days? Okay, because I chose mine. But anyhow, that trial was canceled in March. Yeah, I tried to get Pride Day down there in Elkins, but they didn't want to hear it. You don't want to know what I wore. Okay, let's get me off screen here. That trial right there is canceled on 3/24. 84 days later, 84 work days later, Miss Puckett files a motion. And then, voila, look at that, same day, notice of hearing. So the judge and Miss Puckett's filing a motion to ask for a hearing. And there you go, the same day. But 239 work days in. So now the time of my continuance to the time of my next trial is 109 days. That's a hell of a continuance for me. I got 109 workday continuance. Look at that. I'm the boss, man. I am telling you that I don't ever think that I've ever heard of somebody getting 109 days of a continuance. Wait, what? What? Huh? That's pretty good. Let's go look at the numbers again, just to be sure. I filed my motion to continue at 150 days, work days. From that to the time of the next trial is 109 work days. I mean, I went through, let's see, 7. I went through all up clear up to Labor Day. No, 4 holidays I missed. She asked for a speedy trial. Well, she ain't getting one. Okay. So what happens in between that 109 days? And this is why these are blue. Between 8/31 and 4/19, what the fuck happens? That's 166 days. Well, I'll tell you, my trial happened where it was continued, event closed. So between 8/31 and 4/19, or 5/02 over here, that's 166 work days between my continuance, these 2 delays, plus this one. What does that add up to? That's 109, right? 178, 200. That's 109, 209 plus 66. Math is horrible. I need to get that in there, the total of these days. But you're talking 166 work days between my trial, which was continued, to a hearing. So whenever you have such, I mean, that's a hell of a continuance, right? Yeah, 275. I had it right. 275 days. From this scheduled trial, from my continuance. So in essence, I've had a 275-day continuance. Look at me go. Look at me go. 275-day continuance. Take that and that and that. Miss fucking Puckett, Ricky Bobby Sue Jones. Now wait, why does this all matter? Why? What are you rambling about, Tugga? What the fuck are you talking about? 430 total work days. 635 calendar days. 203 skipped days. 90 Saturdays. 91 Sundays. And 22 holidays. Okay. Is that an excessive amount of time to try a case? How long have I been under detention? 430 days. That's how long I've been in confinement. $630 days is a long time, but only 430 in work days. Only. So, why does this matter? How long does it take to try somebody? Okay. One more point about this chart, and we'll kind of get away from the chart, and we'll get back to why this chart is important. Okay, over here. At 1/3/2024, I filed a motion to disqualify both the magistrate and Miss Puckett. Between this trial, where witnesses were on the stand, evidence had been admitted, testimony was given. Now the judge is gone. Well, I filed a motion to disqualify the judge first, and District Attorney Puckett. So from the date of my trial, August, September, October, November, December, January. August, September, October. Okay, that's no August. Let's do, because that's 31. September, October, November, December, January, February. From that to my motion, or January, 5 months from my motion after my trial. I waited 5 months, almost 5 months, to file my motion to disqualify based upon their actions, which I've proven through video cameras. I filed my motion almost 5 months, if not a little bit over 5 months, work days. Well, no, 166 work days in essence. But that's what happened in between my motion to disqualify. Well, you say, well, how could your motion to disqualify take that long? What are the rules and procedures for that? Well, there's an answer. Rules and procedures for magistrate court, it goes this way. I lost my train of thought there for a second because I thought of something else. Okay. To disqualify a judge, you must file a motion to disqualify. It goes to the next judge up, which is a circuit judge. That circuit judge has 5 days to rule. 5 days to rule on your motion to disqualify. If there's cause and they say, yep, judge, magistrate, you got to go. You're disqualified. That judge circuit judge sends it back down to the magistrate court for the senior magistrate to then reassign the case to another judge or magistrate. It's 5 days to do that. So a total of 10 days. Total of 10 days it should take for a motion to be disqualified be heard. 10 days. That's 166 days between my trial and this latest hearing, and 5 months to answer my 3 months to answer my motion. January, February, March, April, May. 4 months. Why did it take almost 4 months for the circuit court judge to answer my motion to disqualify when it takes 10 fucking days? I have to work that into the numbers too. I haven't gotten there yet. There's a definitive number how many days the circuit court judge had my motion to disqualify. And when he answered it, and he only answered it because I called him up, not because they called me. No. The circuit court judge office, clerk of courts, nothing. They didn't call me. I called them. And I said, what about my motions? I filed them a long time ago, months ago. I mean, it has to be Christmas Day, New Year's Day. Little after New Year's Day. I mean, again, I'm missing New Year's Day because I'm filing motions, calling you up. I miss Christmas Day. All them holidays that year are fucked for me. Thank you. But I didn't say that in the phone calls. But I said, listen, did the judge read my motion? Well, it's on his desk. It's a lengthy motion. I said, yeah, it is. Well, he'll get to it. Now, he hasn't had time to read this lengthy motion to disqualify for 4 months, almost 3 months, work days. I haven't exactly worked the work day, but it's well over 30, 40, 50 days, easy. For him to answer simple fucking question. Is the magistrate and district attorney disqualified? Judge. It's part of your duties, judge. Keep the flow going for a speedy trial. For me, first and foremost, and second, for the cost of the courts. How much does this fucking cost the courts? How much does this cost the courts, Judge? I'm not going to name your name right now. You've done nothing to me except let this charade happen. But that's fun. You're a busy guy. So I filed a motion to disqualify. And 3 months later, I'm calling him up saying, hey, where's my motion? What happened? He answered it. He denied my motion. I got a letter that I haven't figured in here yet, so I don't know how many days ago it was. One of these. It's one of them. So in total, from the time I had my trial where testimony was given and the new hearing is 166 days to hear a motion to disqualify halfway through, over halfway through. That's right, line one, it was denied. So what is a speedy trial? What is a speedy trial? Is 430 days a speedy trial? is 635 calendar days, 203 skipped days, 90 Saturdays, 91 Sundays, 22 holidays. Here's all the holidays I've missed. All of this right here. Does that afford you the opportunity to carry it out for 430 days? There are definitions of it. You know, there are definitive rules. And it all starts from a case called Wingo. I think Baker or Barker versus Wingo. It's a 4-part test, like the Supreme Court likes to do them tests, you know. And the four-part test tells you, well, the speedy trial, after all these years, you'd think we'd know what the fuck a speedy trial is by now, don't you? But no. Do you understand? This is why I rub my face. This is why, here, copy, enjoy. This is why I rub my face. Because me and you, Lion One, Thin Blue Line Slayer, and Creole, and Raging Cajun Randy, and, you know, Jack Off Jack, and Nat, specifically Nat. Anon Mouse, Sewer Dog, the Patriot, you know, Benghazi Rabbit. You all know that you, in order to prepare for combat, you must be armed. Even though your opponent is easy prey and they don't have the right armor, and you know you're going to slaughter them, don't feel sorry for them, but still be prepared. So, in order to argue a speedy trial, determination in West Virginia, what are the rules? What are the guidelines? What's the case law, right? Don't you want to know? Isn't that where you would go? Isn't that where you would want to get your armor up? Of course it is. So let's get our armor up. Let me bring this over here. Yes. Here we go. Okay. You first start off by what you're going to argue up front, up first, in front. Because remember, I started off with a jury demand right here. 9/22, 30 days in, I asked for a jury trial. Rules state 20 days, okay? Magistrate Court 55-8, a trial by jury, trial of the court. A party to a civil action which doesn't apply. A defendant in a criminal trial for a misdemeanor offense triable before a magistrate has the right to demand the matter be tried with a jury, be tried with jury. And the defendant shall be advised of his rights in trial, blah, blah. A demand by the defendant for a jury trial must be made in writing not later than 20 days. I did mine in 14, after the defendant's initial appearance before magistrate, provided that the case is indigent, blah, 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 blah. Okay? Okay? And since I'm not in a jury trial, even though I asked for one, and I'll tell you why it's important. I'll tell you why it's important that they selected a non-jury trial for me. Is because they didn't want it to be recorded. The magistrate in a non-jury trial does not have to record, but he does with a jury, which means I have a court of somewhat record, because it's not technically the official record, believe it or not, but it is. Upon reproduction, put it that way, to me or you as a defendant or a prosecutor or whoever else. Freedom of information. Okay. So where was I? I was at jury trial. I'm not having a jury trial. So, and I believe because he doesn't have to record it. And that's why I was forced, because I asked the magistrate Mitchell early on if he kept a record of it, of my pretrial. And he said, no, don't do that. Just take notes. And that's what the rule says. You don't have to, even at a jury trial, take an audio or video transcript of it. As long as you take notes and advise everybody the reason why you're taking notes and not recording. It's another rule that I'm not really going to get into, but I will explain it to you. So even in a jury trial, the magistrate doesn't have to record as long as he gives just cause why he's not recording and that he's taking notes for appeal. And that's what it says in the right after, for an appealable purpose. Okay. Trial by jury. Done with that one. Okay. Now we're getting into the meat of it. Time for trial, deposition of witnesses for accused, counsel, copy, indictment, and list of jurors accused, blah, blah, blah. When an indictment is found in any county against any person or a person for a felony or misdemeanor, the accused, if in custody, or if he appears in discharge of his recognizance, or voluntarily shall, unless good cause be shown for a continuance, be tried at the same term. So if you show good cause for a continuance or show good cause, you get it, right? But if nobody files for a continuance, which I didn't do in Pitt County, I never fucked with them at Pitt County. I never asked for discovery. I never asked for shit. That's why I was successful down there. Didn't ask for their body cam. Didn't ask for none of it. And they had to try me like that. Okay. Be tried at the same term. I'll read that again. Shall, unless good cause be shown for a continuance, be tried at the same term. Notice, shown for good continuance. Remember the drone footage? Remember drone footage? Motion to continue. 131 days in. Motion to continue by prosecutor Puckett. And look, it was terrible. I missed all them holidays. Well, not many. So is that good cause to file continuance, Miss Puckett? So them 21 days are gone. Them 21 work days are tick, 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 gone. Because that's a frivolous motion. And I tried to call you out on it in my motions to speedy trial and quash prosecution, and a motion to dismiss based upon your fucking erroneous bullshit here. Get it? John D. Nicola, good to see you. You have that great, John D. Nicola, can you send that drone footage to me? All right. For good cause shall be continued, which that wasn't. Be tried at the same term. What does the tried at the same term mean? Can anybody define what a term is? And why they're saying term? Well, we'll find out right here, right now. All right. Well, this one's important too. This is 6219 continuances. This defines what a continuance and how long a continuance can go. Remember, Miss Puckett's continuance went 21 days. The justice shall grant upon a request. And this is criminal procedure. Of the defendant, one continuance for a period not exceeding 10 days. A continuance for a like period shall be granted on request of the state if the defendant has been admitted to bail. No other continuances, listen, no other continuance shall be granted except for good cause or by mutual consent of the state and the defendant. 10 days, Miss Puckett, that you got 10 days from your continuance to trial. I'm sorry, 14 days. See? Notice of hearing. Filed motion here, 217, from here to here. It's 21 days. I'm sorry, 17 days. Am I reading that right? 11 days, which adds up. Her motion to continue, 7 and 28 is 11. So that's appropriate, right? 11 days. That's appropriate. So what happens? I file my motion to continue because she dropped discovery on me in 7 days. And I asked for my return of property and motion to continue. Because look how many days before trial. 315. 9 days before trial, 7 work days before trial. You're supposed to get discovery in 21 days before trial. 21 days before trial, you're supposed to get discovery in. You got it to me in 7 days, so I continued because you said that you had drone footage too, which you never dropped in your 315. As a matter of fact, when you dropped your discovery, you said there was no, Jason said there was no drone footage available. So me be confused. So I file a continuance. Okay. And I have good cause for a continuance. I'm the one that has good cause for a continuance. Not her. So let's go over here. It goes on further, 38.01. It goes further. Cases may not be continued by agreement or stipulation and may be continued only by leave of the court. After a case has been set for trial, it will not be continued except for good cause, which shall be brought to the attention of the court as soon as practicable before the date of trial. 38-0 .01. Rules of criminal procedure for obtaining a continuance. And that's West Virginia trial court rules. Okay. So why do I have, for my continuance, I filed my continuance on 3/17, which knocks that trial out of there. And 84 days later, Ms. Puckett's filing a motion for a hearing. How do I get 84 days and she gets 11? I don't get it. 84 days from the time I filed my motion to continue. 3/24 is the end of the trial or hearing. To 7/27. That's 84 work days. Why do I get that many days? 84 days. What's the delay? Are my motions too hard to fucking read? Return of property? Motion to continue? She's got the magic touch? I understand 315, you drop then and then I'd get a motion, but 84 days before she files a motion. And it's a 239 work days. What the fuck is up with the calculation here? We haven't explained what that means yet. 239 work days. I've missed these days, holidays. Okay, Miss Puckett, notice of hearing down here. New trial date. Notice again here again. Motion 27/27, and the new trial, which I showed up for and was held. Testimony was given. Evidence was submitted. Took 25 more days. So between my motion to continue and the actual trial was 109 days combined. That's a hell of a motion to continue. In practicality, it was 109 days motion to continue. Is that my fault? Can anybody blame me for that when it said 10 days in the court rules for continuances, right? Didn't it say 10 days? Did I read something not right? Well, I think it's an unfair advantage, to tell you the truth. I think that Miss Puckett has been wronged. Yes, I feel for you. Miss Puckett, I wish you want me to give you some of them days back. 10, 20, 30, 40. I got days to burn. I could give you them days back on the mutual agreement, Miss Puckett. Just say Puckett and continue again, please. I've got to repay you. I feel like I cheated you, having all these days to prepare. You've been wronged. It's the judge's fault. Magistrate Mitchell. Got to be him. Let's stick together, sister. Let's go in the united front and say this whole entire system is kind of fucked up right now. You and me, Miss Puckett. Throw Trooper Jones under the fucking bus. Ricky Bobby Sue Jones. Is that what you think it is, Jack Up Jack? A mistrial? But even worse, that's only 109 days. From the time of my trial was over until the time of the next hearing on 5/2, it will be 166 days. That's one hell of a continuance with a little bit of sprinkle in there. Bling, bling. Drizzle, drizzle. 166 days from the date of my trial until the next hearing. Why is that important? You had 430 work days on 2 misdemeanor charges. I was first arrested for failure to ID, obstructing, and then trespassing after I was in handcuffs. Without even being detained. You just scooped me up. Ricky Bobby Sue Jones did. Somebody's fucking with my computer because I'm not clicking that button. There, I unplugged it. Somebody was in control of my computer, probably the FBI, CIA, NSA. They don't know where I'm at. I'm in the bunkhole. 300 feet deep, safe and secure, wrapped in a Faraday cage. All right. So let's continue. We're getting somewhere, though. We are definitely getting somewhere. How do we define speedy trial? What is a speedy trial in West Virginia? And where did it come from? What are the definitions? It all comes from, we love case law, don't we? It all comes from State versus Brum. Okay. Whereas West Virginia Code 62.3-1 provides a defendant with statutory right to a trial in the term of his indictment. You see that? Isn't it beautiful? One term. What is this one term you keep on talking about? What is a term? We still have unanswered questions here. What is one term? Can anybody tell me what one term is, please, before I get to it? West Virginia Code 62321 rather than 6231, which is the legislative adoption of or declaration of the originally constitutes a speedy trial within the meaning of the U.S. Constitution. Okay. Where a misdemeanor warrant in a magistrate court is dismissed, further prosecution for the same offense by a new warrant or by an indictment after 1 year from the execution of the original warrant is barred unless the record shows that one or more of the exceptions contained in that code. And that's like nothing really. Dr. Brum seeks to prohibit respondent magistrate Emily Bradley and prosecuting attorney Jenny Conley from trying him on charges of domestic battery. Dr. Brum argues that such a trial would violate his speedy trial rights, finding that the prosecution did not violate his speedy right trial rights. We deny the writ. Factual and procedural history. On June 6, 2002, the state filed criminal complaint against Dr. Brum alleging he committed a domestic battery on his wife. On August 19, 2022, a pre-trial discovery hearing was held where the parties agreed that another discovery conference would be beneficial, as the alleged victim's hospital records were not yet available. The additional conference was set up for September 4th, 2022, 1 month away. At the September 4th conference, further information was exchanged and Dr. Brum was arrested without a warrant. The state explains that this was a discovery conference that, while not required in misdemeanor cases, is provided as a service to magistrate criminal defendants in Wood County. The state further explains that it is customary in the magistrate court in Wood County to have one criminal day per week set aside where the state and the defendant conduct pretrial hearings in 15-minute increments. Okay. Magistrate set the trial. It goes here. Information was exchanged, and the magistrate set the trial for the next available date, November 18th, 2002. As trial was prepared to begin on November 18th, now it's 4 months. Okay. As trial was prepared to begin on November 18th, Dr. Braun filed with the magistrate a motion to dismiss, arguing that as he was arrested on June 6th, but was not brought to trial until November 18th. As such, his trial exceeded the one-term rule of the West Virginia Code 62-321, as made applicable to magistrate proceedings by the Senate of the state XL. This is what this case refers to. Stiltner versus Hirschberger. The magistrate court denied the motion due to an overcrowded court docket. Yes, the docket was too overcrowded. We couldn't get it in. On that same day, Dr. Braun filed a petition for a mandamus prohibition with the Wood County Circuit Court. That means to eliminate, get rid of. It's a writ of mandamus also. At a hearing at Dr. Brum's motion, which was held that same day, the circuit court ruled against the state. In its written order of December 17, 2022, the circuit court found that the November 18th trial date exceeded 120-day rule. 120. We finally figured it out, Nat. 120 days. Could that be one term? I think it would be. Jack Off Jack is probably saying, yeah, that's a term. John D. Nicola knew it all along. $120 days, according to this case law, Your Honor. Are you getting me, Miss Puckett? And I have a Supreme Court ruling on this, and I've already mentioned it in one of my motions. If you had cared to look at them, D.A. Puckett and Judge Mitchell, Magistrate Mitchell, if you would have looked at my motion to a speedy trial, you would have seen Wingo, but Barker versus Wingo, which gives you the definition of a speedy trial at the federal level. This is at the state level. Ding, 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 ding. Getting it? Now I have on my side federal Supreme Court case law and West Virginia state case law with this case right here. Armor yourself up, people. Armor yourself up. And dismissal was required. The order, however, did not specify whether dismissal was with or without prejudice. What did I write? Let me look. This is my motion to dismiss. I humbly ask this court to dismiss all criminal charges with prejudice against the defendant, Mr. Ballin. Looky there. Would you just looky there? Oh, it's so beautiful. The defense charges violation of his constitutional rights via judicial misconduct according to court rules, procedure, etiquette, and judicial canons. See document 1 to 26 and PowerPoint presentation document 1 to 24 and a thumb drive. Here's the violations right here. First, Fourth, Sixth, Eighth, and 14th Amendment violations, all spelled out. Cruel and unusual punishment via undue length of trial. Look. Now, the Sixth Amendment violation of the United States Constitution, his right to speedy trial and denial of a trial by jury. Them are two good ones, right? Them are two real good ones, Miss Puckett. What about the 14th Amendment violations? Due process, malicious prosecution, Miss Puckett. It seems to be at 430 days. It's starting to look like a malicious prosecution, hon. Just a little bit. Look what I write right here. DA Puckett's unnecessary delay tactics and frivolous motion, i.e. drone footage, continuance, are violations of 14th Amendment, the United States Constitution, due process, and malicious prosecution. The prosecutor has had exculpatory evidence given in discovery, 2021 Fourth Circuit Court, Wingate versus Fulford, maps and deed to the property in question. Due to DA Puckett's delaying tactics and unethical behavior, the defendant has been stripped of many of his rights. See attached documents 1 to 26, PowerPoint presentation, and thumb drive. The defense in 3 discoveries from Ms. Puckett has never received the defense in 3 discoveries from Ms. Puckett has never received the entirety of his GoPro videos and all interactions with FCI McDowell guards on the day in question. The defense has the right to view the entirety of the GoPro videos to bring into full context the totality of circumstances on that day. The defense knows for a fact that his iPhone started video recording because of the sound made when activating video recording from his iPhone that was captured on his GoPro video recording on the day in question. All, if not most, of his interaction with FCI McDowell personnel, in fact, were recorded on his iPhone. See GoPro video on attached thumb drive. Ms. McCabe, in her West Virginia State Police Crime Lab report, falsely claims there is no relevant recordings on the iPhone of FCI McDowell on that day. Tampering or omitting evidence by Ms. McCabe, DA Brittany Puckett, or Trooper Jones is fraud on this court. See attached documents 1 to 26, PowerPoint presentation 1 to 24, and attached thumb drive with video evidence on it. On February 21st, 2023, the defense filed a motion for a speedy trial. The statute of limitations for prosecuting misdemeanor charges in West Virginia is 12 months from the date of arrest. West Virginia Code 6111-9. Through no in capital fault of the defense, this trial is now at 20 months and counting. This is an excessive amount of time to prosecute such simple charges as obstructing and trespassing. Yes, Q sledgehammer, right. Do you see it the same way as my motion to dismiss? So let's continue, shall we? Yeah, that's pretty much it. Yeah. On May 5th, 2023, during a hearing in a separate case, the circuit court was informed that its prior orders dismissing a number of magistrate court criminal proceedings for violating a 120-day rule were being construed as being with prejudice and prohibiting. See, that's where I was getting. I found it right. Thank you, DC Accuracy. Mayo. Okay. I didn't have that in there first, and I'm not going to take credit for that. That was a much smarter man, DC Accuracy. He said, you got with prejudice in there. I said, no, I didn't. That's so stupid of me. So you people do help a lot. And it continues to go on about whether they dismiss it wholly, where they can't bring charges back with prejudice, or without prejudice, and they could then recharge, and it would be a mistrial. Jack off, Jack. Okay? So if the judge would dismiss without prejudice, then they could recharge you for the same crime. It would be technically a mistrial. If it's with prejudice, then that means that you are done. They can't recharge you. They can't fuck with you anymore. Thank you, DC Accuracy. You're my boy. All right. So we got federal case law and we got state case law, right? Boom, boom. Do these fuckers, I'm sorry, Judge, Magistrate, I didn't mean that on you because I don't know you yet. You've done me no wrong other than, oversight, but that's all right. A lot of things going on in your life. I get it. Okay. And this just got thrown upon you because I'm calling. Not because anybody in your court system gave it to you. I called. It's been 3 months. Almost 3 months. From the time the judge gave it to you until the time you're getting back to me. So I'm calling you. What's up? Has it been reassigned? And then all of a sudden, your docket is open for a pretrial conference, not even going back into the trial. Do you understand how crazy this is? We were at trial. Testimony was given. Witnesses were on the stand. The judge/jury heard things. Ex parte communication. Whole bunch of things that this new magistrate can never be privy to. He was never there. Now, the rules state that another judge can pick up a trial, but he got to get himself aware of the case. Now, let me ask you, Magistrate, I'm not going to get on you. You just got done getting this to you about 2 months ago. Well, longer, but me calling about a month or two ago, okay? How can you get informed about a case that has gone on for 430 work days in a few weeks? Magistrate, I'm asking, how can you get yourself even close to understanding what has happened in 430 work days? Even in a year, you couldn't fully comprehend what the fuck is going on, Magistrate. If it was one term, that's 120 days. Work days. Look where we're at. Right here. 430 work days. 120 and 120 is 240. Plus another 120 is 260 or 360. 360 days in a full fucking session, they're called. 3 terms, 360 business days. $360 430 business days. 360 in one session. When it takes one term, just one fucking term, to determine a misdemeanor trial. You get it? 3 sessions is 360 days, work days. You take one term away because you got one term to prosecute. If you take the other one out, that's when you're supposed to prosecute right there. On that finger right there. One term for misdemeanor charge. The total max is 3, 1 year. So that's 360 days, work days, to prosecute me. Subtract 360 days from oops. Can you see it? 360 minus 430. You're 70 days over. If you want to take it to the extreme, you're 70 days over. The 3 term. No, I ain't talking just one. That's right, Joe Black. How many? 1. You're 70 days over the limit. You're coming up on 2 full, one full, you're way past 1 full term or session, 3 terms at 120 days. And you're halfway to the next. Now, would anybody consider that? Would anybody consider that a speedy trial? Okay, so we're done with this case law. We're done with that. See, this is what their event calendar looked like. This is what their event calendar looked like. Let me get off screen. And this is what mine looks like. This is theirs. And this is mine. This is theirs. This is mine. Mine fills in a lot more, doesn't it? Mine fills in a lot more. Speedy trial for an ice age. That's right. That's funny. Okay. So I got it all locked down. I got it all locked down. I mean, dude, the shit that I've been reading, the things that I've been doing are really staggering when it comes to rules, procedure, etiquette, not so much etiquette, rules and procedure and code, right? I mean, I've been really busting my ass. Great, great, great paper right here. Right here. West Virginia University Research Repository. This right here blew my mind. This right here blew my mind. Some very, very, very good people put this together. Justice McHugh. If anybody knows anything about West Virginia Supreme Court rulings, everybody knows Justice McHugh. Continuances. All right, this is the kind of stuff that I've been reading. And I just wanted to get it out. I just wanted to get it out. So, what I'm going to do, just for a little bit, I'm going to open up the panel, see if anybody wants to come in here and explain to me why it takes 430 days to prosecute somebody. Business days. So, if you want to come on up in here, just come on up in here for a brief, little interaction. And I'll wait here. I'm going to drink my coffee. Come on up and explain to me why it takes so fucking long. 3 terms. Is Miss Puckett here? I don't know. Hey, Miss Puckett, let me give you a secret. Afternoon delight. This is afternoon delight. You smoke some afternoon delight and you'll be focused on any case law that you're working on. That's the StreamYard right there. If you want up on the StreamYard, I'll throw it up there again. Just curious, did you ever know what a speedy trial meant? Did I educate anybody on what a speedy trial is? I know Rogue Nation earlier, I was on there, and he was talking about somewhat, how long it takes. And I'm sure he knows what a speedy trial entails. I'm sure he has gone through the same research. So if you want to come on up, just come on up. If not, I'm ending it. I'm done. I don't need to talk to you people anyhow. Greatest American hero, that's right. That's right, you people.
I saved hundreds with Liberty Mutual. Liberty, liberty, liberty. Liberty.
believe it myself. Suddenly I'm up on top of the world. Should have been somebody else. Believe it or not, I'm walking on air. I never thought I could feel so free. Flying away on a wing and a prayer. Who could it be? Believe it or not, it's just me. Just like the light of a new day, hit me from out of the blue, breaking me out of the spell I was in, making all of my wishes come true. Believe it or not, I'm walking on air. I never thought I could feel so free. Flying away on a wing and a prayer. Who could it be? Believe it or not, it's just me.
Yep. I cut the sleeves off, though. It's not effective as a fat man either. I can't play. I play worse than he does. It's not good. So apparently nobody wants to come up, and that's fine. If somebody doesn't come up in the next few minutes, I'm out. I've explained it to you, and I hope I hope I got everything. Nope, my pre-trial is on Thursday. John D. Nicola. Thursday, May 2nd. And in that pre-trial, I'm going over my motion. It's a motions trial. And it's a pre-trial, even though it's past the trial. I don't get it. But I guess you can have motions after a trial's began. But usually the motions should be held like right before trial and then the trial begins again. But even then, I don't even think we should be beginning it again. Even a pre-trial, it's been way too long. 430 days by the time that pre-trial happens. All right. Well, I'm out of here. Nobody wants to come up and chit chat. So, okay. See ya. John D. Nicola. Jack up, Jack. Did you think I'd leave without saying see ya? Ed for action. Good to see you. Lion One, thank you. Thank you. Thin Blue Lion Slayer was here. Creole, good to see you, Creole. Brent, how are you doing, Brent? Thanks for coming. Nat, and Nat. And then there's Nat. And a non-mouse, too. Who else was in here? There was somebody else in here, too. Oh, yeah. The Tribe was in here. And Joe Black. Joe Black was in there, too. Okay, I gave you more opportunity to get in here, but apparently Joe Black is a pussy. Doesn't want to come in here. See you later.